And our state in Florida, we won the national championship that year. And so I know the what you're feeling. I know you're scared. And I told the judges this previously. All these years later, I can tell you that participating in We the People is still the single best academic experience that I have ever had in my life. So take a deep breath. Enjoy yourself. You guys have made it this far. You are going to do so well. Want to thank your teacher and congratulations for making it this far. And I'll have our other judges introduce themselves.
Good morning, Indiana. My name is Gus Chin. I'm a municipal judge from Utah.
Matt's on mute. He's going to figure it out in a second. Oh, he's back on the mute.
Okay.
You're on mute.
I'm good. All right. It's so nice to see you, Indiana. I'm Matt Gutwein, and I'm from Indiana. I'm retired now, but I previously taught constitutional litigation at the Maurer School of Law and worked in healthcare, and really looking forward to learning from all of you this morning.
Well, would introduce yourselves.
Good morning, judges. We are Unit 5 from Team Indiana, hailing from Hamilton Southeastern High School in Fishers, Indiana. All 4 of us are seniors this year. My name is Jake Weber, and next fall I'll be attending Wabash College to study political science.
Good morning, judges. I am Carter Nelson. I plan to attend Purdue University next year to study supply chain, information, and analytics.
Good morning, judges. My name is Donia Zandi, and I plan on attending Indiana University Bloomington next year to double major in political science and criminal justice.
Good morning, judges. My name is Jazz Raja Denoya. I plan on attending Indiana University Bloomington and major in public management and leadership.
And this year we are joined by our wonderful teacher coaches, Miss Janet Chandler and Miss Alana Kane.
Okay, team, here we go. Today's question is question 1. As a result of the decision in Wisconsin versus Yoder, a result of the decision in Wisconsin versus Yoder is that any parent and guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religion's beliefs. Do you agree or disagree with this result of the decision? Why or why not?
Justice Sandra Day O'Connor stated,
Those who would renegotiate the boundaries between church and state must bear one that has served others so poorly.
Jake, Donia, and I disagree with the Wisconsin versus Yoder decision because it contradicts the principle of separation of church and state. Public schools are government facilities funded through taxes. However, churches are exempt from paying any income tax unless they owe income tax from an unrelated business.
The majority opinion by Chief Justice Warren Burger stated values and programs of secondary school were in sharp conflict with the fundamental mode of life mandated by the Amish religion. He also noted that the state's interest in universal compulsory education is by no means absolute to the exclusion or subordinate to all other interests. This decision favors more religious liberty.
I agree with the decision. In San Antonio Independent School District v. Rodriguez, the Supreme Court refused to examine the tax system funding education. This precedent, while 10 months after Wisconsin v. Yoder, affirmed the Constitution does not guarantee a fundamental right to education. However, the Free Exercise Clause of the First Amendment guarantees freedom of religion. This explicit free exercise clause and the lack of educational guarantees proves Wisconsin v. Yoder was a correct analysis, and that religious rights may supersede educational requirements.
In the Constitution, the 9th and 10th Amendments help provide for the right to an education. These 2 amendments work together to ensure that just because the right to an education is not listed in the Constitution, that a person cannot be denied this right as it falls to the state governments. 22 state governments directly list the right to education in their constitutions. However, all states offer a public education to their residents.
The Indiana State Constitution dictates in Article 8, Section 1, to provide by law for a general and uniform system of common schools, wherein tuition shall be without charge and equally open to all. This protects the right to an education by ensuring all public schools will be held to the same standards through uniformity, and that it shall be without charge.
The Virginia State Constitution protects the right to an education in Article 1, Section 15. The General Assembly shall provide for a system of free public elementary and secondary schools for all children of school age throughout the Commonwealth, and shall seek to ensure that an educational program of high quality is established and continually maintained. This protects an education by ensuring it will be high quality in its content, and that all children of school age will be able to receive such schooling.
Courts have balanced religious beliefs with other rights in many ways, both defending and superseding religious rights. Sherbert v. Verner ruled government cannot set certain employment eligibility requirements if it interferes with one's religious beliefs. The court balanced the right to religious freedom of the Seventh-day Adventists with the right of the government and businesses to set eligibility standards for employment.
However, the court superseded religious rights in Brown versus Roy of 1986, where it determined religion does not exempt someone from complying with federal regulations for Social Security, superseding the right to freedom of religion.
Former U.S. Representative Joseph Kennedy III stated,
There is a difference between exercising religious beliefs and imposing them on others. Our Constitution fiercely protects the former and expressly prohibits the latter.
This is the conclusion of our prepared testimony, and we are now ready for follow-up questions.
Thank you very much. So let's talk about this in kind of the context of what we're living in today. In the world of COVID and a post-COVID return to school, what does that look like as a way of balancing religious freedom and the state's interest in ensuring that students are safe? So specifically, as it relates to vaccinations, what rights should be balanced, and should states require vaccinations for students to return? And what, if any, exemptions should be allowed for if someone decides not to get vaccinated? So talk to us a little bit about that.
Personally, I believe that state governments should require vaccinations to be able to return to schools, specifically for college students and for students in the primary and secondary schools, to ensure that the learning environment is maintained and that everyone is able to be healthy without the risk of increasing or having another curve. I think that that would be one of the easiest and most effective ways to ensure that people maintain a safe lifestyle while also learning.
Following following the reason from my colleague, in our school district, if you cannot take a vaccine that's required, because in our school district, we do have to take vaccines when we graduate high school. So there is a form that we have to fill out if we have another reason just to not take the vaccine. And that can be for many reasons. That can be established for many reasons. However, in the court case of Jacobson versus Massachusetts, in which during the time when the smallpox pandemic was going on in the country, Jacobson, who was a pastor, didn't refuse to take the vaccine. However, in Massachusetts, it was ruled that Massachusetts used a correct police power when it comes to protecting the health and the public health and the people. So currently in our pandemic, we're still seeing some cases rising in different states like Michigan. And we do need to make sure that we keep our public much more healthy so we don't see an increase of cases in the future.
However, when looking at Jacobs versus Massachusetts, they also did set the precedent that there are special exceptions to vaccines, and that would include religious beliefs. Jacobson, in this case, just did it for health benefits, not for a religious belief. And when it comes to schools, those that their religious belief would say that they don't want to take the vaccine and their belief goes against taking the COVID vaccine would mean that they still are entitled to a right to education in the states that include it, like Texas's state constitution guarantees education. However, federally, you can also argue that they still deserve an education through the 14th Amendment. Roughly 3 years ago, the Federal Court of Appeals ruled education in favor of the 14th Amendment Equal Protection Clause when a group of Michigan students were failed to taught to read and sued and said that it violated their equal protection, and the Federal Court of Appeals said it did.
Thank you. I have a question. Given the fact that you have this disagreement amongst yourselves, support and opposition, how do you balance the right of the student to an education for a good future versus the parents' religious beliefs? How would you argue in favor or in opposition?
I believe in the case of Wisconsin versus Yoder, it really helped because the student himself actually testified saying that they believed in this Amish religion. If it had been only the parents' belief, I think there would be very difficult and very gray area about whether the right to education or educational compulsory education supersedes the parents' religious beliefs. And so I think there needs to be a fine line where it's not just the parents' religious beliefs, but actually the students' religious beliefs. Because a parent, while they are an adult, the student should still have a voice, even though they may be a minor.
To continue my colleague's point, that was something that the justices brought up during oral arguments and additionally in the dissent, is that it could lead to an issue in which a student wants to maintain that right to an education, but the parent decides to pull them out of it, citing a religious reason. And the main reason why the majority opinion found in favor of Yoder, sorry about that, was because that it was that student's testimony, that students testifying at trial really helped push them to where they realized that it was a consensual break from school with both the student and the parent desiring that decision.
Additionally, I believe it would be a little bit hard to balance depending on state to state. There's obviously a difference in liberal states versus conservative states on how they approach this issue. So I think if you look to the state's education laws, that's how you could best determine how a state would approach this topic.
Let me ask a hypo based upon the Yoder analysis and the Yoder outcome. Instead of Amish, what if there was a religious sect that did not believe firmly and sincerely, and for decades, that girls should have any education at all, and therefore did not allow girls to attend any formal public school in a state like Indiana that has a compulsory education law that makes it a criminal violation to not attend school? How would the court address that hypothetical?
I believe hypothetically, in that case, it's a law of general applicability. And in that sense, it wouldn't necessarily violate that religion because it applies to every single student that's within Indiana's jurisdiction.
But Wisconsin was also a law of general applicability. It applied to every student in the state of Wisconsin. So that doesn't distinguish it from Yoder.
In the Wisconsin v. Yoder decision, the Wisconsin Supreme Court felt that there was a sufficient enough state interest to maintain an educated populace to force Yoder to attend school. The Supreme Court felt that that state interest was not compelling enough, and that's one of the reasons why they found in favor of Yoder. In this case, they were still maintaining an education. It simply was just ending at the age of 13, 15, something along those lines. However, in our hypothetical here, having that person receive no education at all means that they are at a severe disadvantage and are more likely to be a severely undereducated citizen. And therefore, I would argue that there is enough of a state interest to force them to be able to attend public school.
I think you can actually see this as a possible strict scrutiny case because of the Equal Protection Clause and the precedent set by Brown versus Board of Education. While desegregated schools, that would also include desegregation based on gender. And under those principles, I think the Free Exercise Clause would come into very sharp conflict with the Equal Protection Clause of the 14th Amendment and previous court precedents. And I think based looking at the courts, they would actually favor education rights given to those that are women.
But doesn't the Tandon decision make it clear that free exercise rights are subject to strict scrutiny as well? In other words, the state must satisfy strict scrutiny in order to limit free exercise rights.
Time.
Saved by the bell.
Hey,
Congratulations, students. There's a wonderful presentation, and I just want to thank you and your teacher for just a wonderful participation in the program, and the judges are going to now provide feedback.
okay, well, I think that you all did a great job. I like that everyone participated. I like the use of quotes in your prepared statement. I think that was very good. And I also kind of liked, I wasn't sure where you guys were going at first, disagreeing, but I liked that you provided both kind of both sides. You'll realize in life there's always multiple sides to an issue, and I think you all did that very well. And then in our follow-up questions, we threw out at you some different hypotheticals, and no one hesitated. Everyone kind of went at it right away. So again, I think that you all were very well prepared, very polished, and were able to bring reasoning from perhaps decades ago to issues that we're dealing with today.
I agree with the senator. I appreciate your approach. It's wonderful to see that you were thinking on your feet as you were seated there on this virtual process. But also, I like the fact that you attacked it from a perspective of providing example and the authority, the case law that supported the positions you were taking. So very well done. Thank you.
I thought you were spectacular, and I agree with my colleagues. Fantastic use of precedent. Jacobs versus Massachusetts, Brown versus Roy. I loved your survey of state constitutions. Mentioning the Virginia Constitution, the Florida Constitution. I would even have been tempted to brag a little bit because the Indiana Constitution was the very first state constitution to guarantee a right to a public education, which I think you probably knew that. So in your future presentations, feel free to brag. Oregon then soon followed after Indiana, but also very facile with the day's events and this very complicated issues of balancing these rights. So really wonderful presentation, and a pleasure to watch you do your thing. So thank you.
Thank you all very much.
Thank you, judges.
Thank you so much.
Thank you so much.
And thank all of you. And I am going to, the judges will be going out back to their breakout rooms. And I just wanted to, once again, thank the judges and thank the teacher, and also thank you, Indiana students. Well done. So
And thank you, Ms. Chandler, as well. Yes.
Oh, yes, absolutely. So thank you all. We really appreciate your participation, and good luck, Indiana, for the rest of the day.
Thank you very much, Dr. Toma.
Bye now.